Just waiting for Ed to join us and then we'll make a start.
Great. Can I just check people can hear me?
Yes.
Good.
Me too.
Hi, everybody. I had set up a quick meeting before, but I don't know.
Oh. Poor Leslie's just been booted out. Leslie can hear us.
Hi, Ed. I think we are now in the live sessions meeting and it's just gone 1:30, so should we make a start? Is that all right?
Sure.
Great. Okay, good afternoon and welcome everybody to the first session of the afternoon. We're going to explore the legal and ethical challenges of scaling up this small project that we've started, following on from Professor we've in our study, and we're also going to address the short and longer term legal and procedural reform issues that arise. I'm Dr Jenny Driscoll. I'm a senior lecturer here at King's, where I run the MA in Child Rights and Development. And as a former child protection barrister, I'm particularly delighted to have the opportunity to chair this session and open up what's a very sensitive area to discussion. So as we've heard, the proposed use of DNA testing to trace the fathers of children born to aid beneficiaries has become a controversial topic, and very similarly to the issues that Julia Gillard described this morning in relation to review child sexual abuse. Critics claim that the process has the potential to re-victimize victims and also that it can raise expectations where there's little chance of success. And of course, we heard from Margaret Simons earlier today that it doesn't guarantee success, and there are some cases that she met a dead end, and also that it can thrust victims into long drawn out legal processes where the outcome is guaranteed. And there are other worries about the impact on other family members and also the rights of the child should they discover that their father's from another country. On the other hand, children have a right to identity, which is a very fundamental right. It's a right that includes the right to know their parents, and they can gain very many important practical benefits from that knowledge. So tracing a child's father opens doors to child support, to enabling them to claim their rightful nationality, and in some jurisdictions and where the mother's under the age of 18 at the time of procreation, it may give the ability to prosecute offenders full and foul of child sex offence laws. Our project has benefited enormously from the expertise of three leading international lawyers, James Netto, Parosha Chandran and Ed Flaherty, and they are going to explain their experience in addressing the legal and ethical dilemmas in this area and talk about what legal reform and support ensure accountability. So James is in the International Family Law Group. He specialises in all areas of children's law and particular expertise in children matters. James is highly experienced in cases concerning the international movement of children, complex parentage disputes and human rights issues. Parosha Chandran is a professor in modern slavery law at King's College London. She's a human rights barrister at One Pump Court, and she's a specialist in modern slavery law and a world-leading expert in the law relating to human trafficking for the United Nations, the Council of Europe, and the Organisation for Security and Cooperation in Europe. Parosha represents both adult and child victims of modern slavery and human trafficking, and she set critical legal trafficking precedents in the asylum, slavery, criminal and public contexts. And Ed Flaherty is an Swiss law firms of AF Partners and Schwab, Flaherty and Associate in Geneva. Swiss Association members and third parties or injured by international organisations such as the International Organisation, World Trade, UNAIDS, the UNHCR World Intellectual Property Organization, the WHO, ILO, and others. He's the founder of Watch, the Centre for Accountability of International Organizations, and also not-for-profit association Hear Their Cries with Professor Andrew. So welcome to all. The structure will be 3 brief 10-minute presentations before we open questions. So please take any questions that you might have in the Q&A tab on the right hand of the screen, and have as many as we can the time available. So please note, as with the other sessions, this session will be recorded. So I'm going to hand over now to James. Thank you, James.
Brilliant. Thank you very much, Jenny. Thank you for that lovely introduction. So my name is James, and I'm a solicitor advocate and partner at IFLG in London. And as Jenny says, I specialise in all sorts of weird and wonderful cases involving children. Now, in particular, why I'm so interested in this case, that particular area I do is declarations of parentage. And I was the solicitor involved with Madeline and Melanie, who were the children we saw in the previous presentation and we've been speaking about today. And it was a great honour to represent them. And it's something that I, along with many others I know in this panel for sure, are very passionate about. What I would like to do today is speak a bit about declarations of parentage from an English legal perspective. So a declaration of parentage it's set up by the Family Law Act 1986, and it reflects who is or is not a parent of a child. So any applicant or any person who's got a vague interest in these proceedings can make an application for somebody to be a parent or declared to be a parent or not a parent of a child in question. And child is used very liberally, so it can be an adult child, it can be a child under the age of 18. And the English court, and in particular the High Court, has jurisdiction in cases for applications of declarations of parentage, where any person involved, either the applicant or the respondent of the child, is either domiciled in England and Wales, so living there sort of for life, habitually resident in England and Wales for at least a year up to bringing this application, or if one of these people has passed away and died and was habitually resident in the period a year before the person's death. So this is quite important for us to know the jurisdictional basis. So as much as I would love to run with many of the other cases that we have between the Philippines and Australia and the Philippines and Canada, we are, in England at least, confined to those who have a nexus with England, and that is generally speaking going to be an English gentleman who has fathered a child abroad. Now, this legislation it's not a common beast, as it were. You don't generally see these applications going through the court. And when you do see a declaration of parentage, it tends to be some sort of rock star or football player who one night has had a bit of a romantic or less romantic dalliance with somebody, and 9 months later a child is produced. And the question then becomes, well, is this person that parent? Should we declare who it is? And if so, then inevitably there's the question about child support and access and contact, custody, however you want to frame it. And I've certainly done cases where rock stars and footballers and other famous people have been involved in a declaration of parentage case, but we're extending this vehicle to use it for some of the most vulnerable people who you will see going through the court, and that includes women and children who are the victims of sexual exploitation, included by aid workers. So this is the tool we are using to go get them. And the reason behind this is because a declaration of parentage is a declaration of the court. It is a court order made by the High Court usually, and the High Court will make this declaration that a certain person is or is not a parent, or generally speaking a father of another person. And that binds everyone, and that can have, as Jenny raised, enormous consequences for a child's identity, yes, and family unit, yes, but also tax implications, nationality implications, child maintenance, child support, immigration issues. It can affect people internationally. So it might be that they gain or lose a nationality. The ramifications of a declaration of parentage are huge, and they need to be dealt with very carefully. But what I really wanted to talk about today is the real challenges in scaling this up, and in particular what this means for people in this situation. Now, we've been looking at it very much and continuing the theme from what we were discussing this morning and what we've been hearing about, is the having mothers and children in countries, here, for example, let's take the example of being the Philippines, and a prospective or putative father in a different jurisdiction, here, let's say England. And quite aside from the power imbalance and the exploitation that can and does arise in many of these cases, the real challenges, of course, and these, they almost go without saying, but they're worth considering, of course, the questions that the issues that these applicants, so the child and the mother, will face in this access to justice. How is somebody who is living on a rubbish dump in Angeles City, like Margaret was talking about this morning, meant to launch complex declaration of parentage proceedings in the High Court in London? You know, hundreds of miles away, thousands of miles away. It's just not something that can be done very easily, but it's not impossible. The courts in this country is very used to dealing with a lot of international children cases, and they will extend a considerable degree of latitude to this. So they will allow video link courts. They will ensure that people do have access to justice. Certainly the cases we've been doing so far, we've been doing pro bono, and I know that there is an appetite amongst lawyers at the moment to do this sort of work pro bono. I know there is, and hopefully it will continue. But we're also exploring legal aid, where the legal aid in this country can be used to fund proceedings in this jurisdiction. So that's something we're intrigued about, quite aside from all the sort of boring technical aspects of it. How do you locate these fathers? If you've got the DNA test, great, but you need to have something that pins it to a certain individual. And it might be that you have information that says, oh, I know Mr. Smith, and Mr. Smith was working for Oxfam in this city between X date and Y date, and that's when this child is likely to have been conceived. Well, then what you might be asking the court to do is make an order against, say, Oxfam or any other charity, saying, please provide me with a list of everyone who was in this, and then you try and isolate it that way. But there is an element of it bordering onto becoming a fishing expedition, where you're just going out there trying to throw out something and seeing what you can get back. And judges are reluctant to do so, but I think judges do have a certain amount of sympathy for people in these situations. So that's part of the practical challenges that we face. But let's say you do have a father, and in the absence of DNA testing that pins it on an individual, you can still ask for this DNA evidence to be done in court. So one of the first stages will be the court inviting a father and the subject child to provide DNA tests. And now in this jurisdiction, you cannot force somebody, you can't compel somebody to provide their DNA. Now, if I say, I think Mr. Smith or Mr. Jones is this person's father, the court will say, all right, Mr. Smith or Mr. Jones, you're invited to provide a DNA test within 21 days, for example. And if Mr. Smith or Mr. Jones says, well, no, I refuse to, where do you go from here? The court is allowed to draw adverse inferences. There may be a reason why this gentleman doesn't want to provide his DNA test, but I've yet to hear a very good reason for failing to do so. If you're so sure that you're not the father, this settles it once and for all. And trust me, there are cases where you get the DNA test and you think, oh, goodness me, this father is not the father. But then you rule out the proceedings and you withdraw the application. But an adverse inference can be drawn if a gentleman in these, well, if anyone, but in particular in these circumstances, a gentleman refuses to provide his DNA. But let's say you don't, and this gentleman insists on the adverse inference being drawn, and he says he is not the father. Well, what do? Then it becomes one of the burden of proof. As lawyers always like to talk about proof. How do you prove this? And a lot of it might be circumstantial. You might be able to ascertain that this gentleman was in the Philippines, for example, between X date and Y date certain years ago, and 9 months later this child came out. But that's one point. But also, the question that will be asked is, what does the mother have to say about this? And do you put the mother in the witness box? Do you ask her what her sexual history was? Do you ask her whether she's a sex worker? Do you ask her if she's had sexual affairs with any other individuals? Now that, if I'm representing a mother in those circumstances, on the one hand, the proof of a declaration of parentage is so life-changing, but on the other, you are, as Jenny says, re-victimizing the victims. Are you going to ask somebody who may have been raped, who may have been sexually abused, who may have been exploited, to relive these experiences in order to get a declaration of parentage in front of a court, hundreds of thousands, well, dozens of thousands of miles away, so in proceedings in a different language, through an interpreter, via video, in a different time zone? It all starts to just unravel. And these are considerations that any applicant and any mother in these circumstances will have to bear in mind that there is a risk of this occurring. Judges are very loath to do so and will put as many protective measures as in place, and you'll have to do statements, and we'll see whether those written statements are acceptable at face value. But it's still, well, the father is still entitled to challenge evidence, and lawyers are meant to challenge evidence in order for the judge to be in the best possible situation to come to a conclusion. So the answer is there's no real outcome that suits everyone. And also, you may get these declarations of parentage, but what are the scars that are left on this family decades later after this litigation, re-traumatizing these victims? So I don't want to sound too gloomy of it, because there is a vehicle for this court, at least in this jurisdiction, and in many jurisdictions around the world, as we've seen from the Canadian cases and from the Australian cases, for women and children in these circumstances to have justice. And that is what is vital. But these women and children need to go into it with their eyes open, with good lawyers and facilitative and helpful judges, and in circumstances whereby they need to realize what they're getting themselves into. And I think that is certainly a challenge that we will have to deal with sooner or later. I think on that note, my time may be up.
Thank you. Yes, perfect timing. Thank you, James, for that fascinating insight to the realities, the legal complexities of running these proceedings. So I'll turn now to Parosha, who's going to highlight some of the deficiencies in the law further when supporting victims of abuses, and talk maybe about where national and international law might be reformed in this area. Thank you, Parosha.
Thank you very much, Jenny, and thank you, James, for explaining your work in the field, which is very different to mine. I'm a relative newcomer to this field of the exploitation of women and children by aid workers in terms of the expert group. I've been involved for a few months, and I've been thinking about what might need to change. So I'm a human rights barrister. I've been practicing for 24 years, and certainly for the last 2 decades, I've been bringing test cases to establish rights for victims in vulnerable situations, predominantly victims of human trafficking and modern slavery. And so my process has always been to look at the law as it stands, to hear the plight of victims, whether it's from NGOs or from solicitors who come to me with a client, and then to see where the gap in the law exists that is enabling impunity or a lack of protection for the victim, and then using my skills as an expert in the law to seek to plug it by bringing test litigation. So my area of work has not involved James's specialisation, which is declaration of parentage in these cases, but I've been looking at the plight of children, for example, who have been abused in refugee camps by soldiers who are there to protect them. So I'm just going to give you a bit of a snapshot really of where I'm thinking, because I think we're at the beginning of this, for me anyway. And really what I'd like to do is create a dynamism around looking at possible reforms and even a possible declaration that could have significant weight to consider these cases. Now, I was first interested in this field because many years ago, back in 1999, I was working at the Office of the Prosecutor for the War Crimes Tribunal in The Hague, the International Criminal Tribunal for the former Yugoslavia. And years later, we came to hear about the abuses committed by the services in Bosnia under the auspices of the UN. And of course, that really spelled out. Then a few years ago, possibility into liability for DynCorp. DynCorp was the employer of those servicemen in Bosnia who were under the UN contracts. And so I really focused as much as I could on trying to see if there was any liability, civil liability potentially. But it really was impossible because the contracts are extremely carefully drafted to enable no external litigation whatsoever, and that all the decision making as to any complaint lies within the UN itself. So it was interesting to me to see such steel walls. Now, of course, Intersec, the action group of King's College London, of which I'm a member, is not looking at the abuses by the UN peacekeepers. It's looking at a very critical area that is in need of desperate attention, which is the abuse by civilian aid workers and the need for accountability. So in my field of modern slavery and human trafficking, I've been involved in setting, as I said, test cases for trafficking victims. And what we see anyway with the international framework of legislation, which arises from the Palermo Protocol in 2000 on trafficking against persons, and then was picked up by the Council of Europe Convention on Action Against Trafficking in Human Beings 2005, which is actually really the best blueprint of protection for victims of trafficking in the world. And then there's also developments from that in the EU Trafficking Convention 2011-36 EU. Is we see three parts, which is the protection of victims, the prosecution of offenders, and the prevention of trafficking. So these three P's are taken as being the formula for combating human trafficking. And so I'd like to apply that in a little way to this discourse, because as I say, we're at the beginning. So I'm just talking through some thoughts that will develop, and no doubt, down the line, we'll be having another conference when perhaps we'll have been able to actually put some muscle onto the bones of what I'm about to describe. So when it comes to the protection of victims of trafficking, some of the problems that have arisen when we're looking at the victims of this different form of exploitation in some ways, sexual exploitation and abuse, which is not described as trafficking per se, is that one of the colleagues earlier said that it's really for self-reporting of abuse allegations that's required. And how can anyone be convinced to do that when they're a victim? They might not know that an offence has been committed against them if they agreed to sex for survival purposes, whether it was shelter, food, housing, or job, for example, or their child was sick, they need medicine. So when it comes to that, in the trafficking field, we have what is very now clear is strict requirements of training for those who are in the parameter of potential victims, to be able to identify who potential victims are. And that is to reduce the burden on a victim to have to report themselves. It's also clear from what's been said earlier that other people know what's going on. So if somebody is abusing somebody, it's quite obvious probably to other co-workers that they know what's happening. So why don't we then start considering within the civilian aid workers context a duty to report sexual exploitation and abuse that is actually legally enforceable? Because if you're letting it go undeterred and unmarked, then you're surely complicit yourself in enabling that harm to be continuing from the moment that you know. Another thing that we have in human trafficking is case law from the European Court of Human Rights, and some of my cases as well, where I established in the UK in 2008 and the European Court of Human Rights established in 2010 in a case called Rantsev, the duty on the police to investigate where there's a credible suspicion of human trafficking, a reasonable suspicion of human trafficking. And so again, it's not to require the complaint of the victim that there needs to be an investigation, but, and it wouldn't just mean the police, it would mean any state authority would need to investigate. So developing that in the way that we're looking at now, where inevitably every single one of these aid workers is in a particular country under an employment contract with an organization, why don't we start requiring a duty to investigate on the organizations where there is suspicion or reasonable suspicion of abuse. So then what we also have in human trafficking is looking at protection. So as soon as somebody is identified as being that given assistance, appropriate housing, information on relevant court and administrative proceedings, assistance for their views to be heard, medical, psychological, material assistance, employment, education and training opportunities. And I'm reading under the Council of Europe Convention, the Palermo Protocol, the UN Palermo Protocol, Article 6. And so what I'm also thinking here is, like, what is the base cause of the inequality? It's generally poverty, isn't it? And a lack of opportunities for those who are the victims. So why not then require organizations who are in a position of power such that they have employees acting within their domain to have a responsibility to the victims of abuse and sexual exploitation? Now, how far that responsibility can go, whether it is to require medical, to offer medical assistance, care, psychological support, to try to find safe housing for that person, or whatever type of safety is needed. I think that's something that, we should be considering imposing. And then I come to the other thing. Under trafficking law, what we have is also a responsibility on the state, and certainly on the perpetrator, if the perpetrator is discovered by the state, to compensate, civil compensation for the harm done. And that, I think, is something we can also look at developing, that if the abuse or harm arises through the worker being employed by the organization, and there were red flags along that way that could have enabled it to stop earlier, or it shouldn't have even started at the beginning, there needs to be accountability for that organization to be responsible for compensating the victim. So my take on this is slightly different in a way from the DNA project that Keynes is involved in, but it develops it to say, well, what are we going to do beyond that as well? Beyond that critical work, and linked to that critical work to enable a framework of protection that can then, I believe, follow in the footsteps of human trafficking, the formula of protecting victims, prosecuting offenders and preventing trafficking through deterrence. You prevent through deterrence and you prevent through awareness. To also enable, ultimately, the best outcome for some of the most vulnerable people on our planet, including children. So these are just some thoughts I have. I have many more that I'd like to share, but perhaps I've come to the end of my 10 minutes already. What I want to say just to end is the abuse of power is gross and extreme. And it is the breeding ground for exploitation and abuse often that exists in the country where these humanitarian organizations are working, because there's been a breakdown of often of law and order, or of rule of law, or a need for compelling assistance and care. And so what we know now with such documented abuse, including the recent commentaries on the DRC and what's been going on there, is to really stand up and start being leaders in this field. And it's going to take a lot of us to do that from lots of different angles. I'm really grateful for the opportunity to be part of this. I look forward to working with everybody to develop some framework of law that can also engage, and this is my final point, sorry, I was about to forget what it was, extraterritorial jurisdiction for international offences. So what I mean here is that where an offender who may live in a Western country or in a country any country in the world, is employed as an aid worker in a country where they have abused or sexually exploited a woman or a child, then they should not be able to get away with it because they've come back to their home country. And we should look at how robust extraterritorial jurisdiction is for the prosecution of sexual exploitation crime. If it's not fit for these cases, then we need to seek amendments and to suggest model laws to states to enable a better response, because no state really wants to be a breeding ground or the hotbed of sexual exploitation and abuse. If they find out that it's happening all the time, there is an imperative and there is an objective to securing justice for those who are harmed. Thank you.
Thank you very much, Parosha, for those insightful parallels with some concrete ideas for how we might take this forward in terms of international law. And that brings us very nicely on to our next presenter, speaker, Ed, who is going to explain the impact that UN immunity has in shielding aid workers from prosecution for sexual offences, and suggest what we might do about that. Thank you, Ed.
Thanks, Jenny. I just want to thank my fellow panel members and you, and also King's College, for having the courage and foresight to host this conference. I think anyone who saw Margaret Simon's presentation a little bit earlier understands how important and impactful this process is. And what I'll speak about now very briefly, and I apologize in advance, it's a somewhat technical area and official. Because of the it does follow up a bit on what Parosha was just talking about in terms of accountability. This is the immunity, particularly of international organizations in the UN, is a great blockade to the accountability that Parosha was talking about, and I'm just going to discuss very briefly that. I come in, as Jenny mentioned, having UN international organization staff members, victims of sexual abuse, and also representing whistleblowers in the same context, and of accountability and ability to find redress in the international organization scale. This also does apply to some degree to the non-UN, non-international organization, non-peacekeeper perpetrators, but less so. But I'll very just. My first sort of point is that what is immunity? Legal immunity means exemption from criminal or law in national and international legal systems. There are many immunities, and they vary from country to country and created by treaty or agreement. Many of you may be familiar with the immunity of American criminal shows, where criminals are granted immunity to testify a co-conspirator or something. Not really. This is more the type of immunity such as judicial immunity, head of state immunity, legislative immunity, sovereign immunity, diplomatic immunity, and functional immunity. Those are the types that do practice where certain acts, as I said, exemption from local or national international laws. UN international organization immunity is sort of essentially derived from sovereign immunity. It can also find basis in the UN Charter. There's a UN Convention on Privileges and Immunities, many national statutes, and as well as headquarters agreements between international organizations, the UN, and the hosting countries provide for immunity. UNIO immunity is similar to sovereign immunity, but sovereign and diplomatic immunity, and it can be absolute or functional. in the UN context, the international organization context, for senior officials, those of the grade P5, their immunity is similar, and as I said before, near absolute. But unlike diplomats, UN international organization officials charged with crimes generally cannot be tried for such crimes in their country of origin, as provided by the Vienna Convention on Diplomatic Relations, which says that if a foreign diplomat is charged with a crime in a host country, his country of origin should actually try the diplomat for the crime in their home country. That's not true for UN and international officials who have the equivalent of diplomatic immunity. They can still be made persona non grata and deported by a host state. But again, unlike with sovereign diplomats, nation state diplomats, they are generally not subject to trial or in their home countries. The immunity for UN and international organization staff members exists for the benefit of the organization, and it can be lifted by the organization against the will of the staff member. But this very rarely happens, and this is one of the problems we see with enforcing or finding accountability in this area. I'll very briefly UNP. Again, that's not really the complete focus of. They enjoy immunity through what's called status of force agreements when in the country of operations. This immunity is also usually pretty absolute in the country of operations. But under most status of force agreements, a soldier accused of a crime is to be repatriated and tried in their home country, but it very rarely happens. There's maybe one or two reported instances of this happening. Staff of UN and international organizations, they enjoy what's called functional immunity. They're immune from civil or criminal processes arising out of the performance of their official functions. For example, if a organization driver hits a pedestrian and kills them, they cannot be subjected to civil or criminal process for. But if it happens off duty, they certainly can. Now, the host country international organization and say, please lift the immunity of the driver. We want to charge him with a crime for the accident. Again, that's up to the organization to decide whether it should lift or not. And it happens occasionally, but probably less so in EA. Immunity of the UN and IOs often leads to the impunity that Parosha had talked about on the part of the keepers and also senior managers, which is evidenced by the plethora of reported cases of sexual abuse and sexual harassment in international organizations. For example, in a 2009 internal survey, 1 out of 3 UN staff reported having been sexually harassed in the previous 2 years. Immunity leaves SEA victims and whistleblowers who have been retaliated against with the sole option of to turn to their perpetrators or the perpetrators' employers for redress is access to national guard by the international organization and UN immunity. With the UN or the IO sitting in judgment of its own staff and their misconduct/crimes, for which the organizations and its senior managers might face civil or criminal liability themselves if the claims were brought in national courts, it's no wonder that victims and whistleblowers decry the so-called internal justice systems of the UN and international organizations. A number of cases in the federal court system and before the European Court of Human Rights challenging UN and international organization immunity, but to date have all been rejected. If the UN international organization eliminated or revised, which is quite feasible, the following is quite possible. For the perpetrators of rape on underage victims, DNA matching could be used to track down the perpetrators. And for those coming from countries with sex tourism laws, generally just in the West, such DNA matching could be used to prosecute them in their home countries under such sex tourism laws. In some instances, if the perpetrators were negligently deployed by their organizations, say the perpetrators were known sexual offenders but were still sent to the sex tourism laws could also be used to hold the organizations and their senior managers liable, either civilly or criminally, for aiding and abetting the sexual abuse. For UNIO staff members and peacekeepers that father and abandon children in their fields of deployment, DNA matching could be used to locate others to bring child support action in the father's home countries. Again, one of the limitations we find in the project and Hear Their Cries is using the publicly available DNA databases limits the number of people who can be helped by this. We're generally looking for Western fathers or Western perpetrators, and hopefully over time we'll develop a better way of expanding that beyond just for Western perpetrators or Western fathers. But that today that is certainly a problem. Today, all of the above solutions are possible if the immunity of the staff members, peacekeepers, is waived. But as the waiver can only be done on a case-by-case basis, it's a long and arduous process. And this acts as a disincentive who wish to seek redress if they so choose. A better approach would be to allow for the automatic waiving of immunity in cases of SEA or paternity, or better yet, to convert UNIO immunity to an affirmative defense that could be pled before criminal court, rather than as today acting as an absolute bar in most cases to most civil or criminal actions. Just like to point out, its close relation, sovereign immunity has outlived its intended purpose, which was to ensure the survival of the fledgling national organizations when they were created after World War II. But in my opinion, in my experience, now does more harm than good. The following quote is from a U.S. court case in 1966 on sovereign immunity. But in my experience, I find it equally as applicable to the UNIO immunity today. Quote, "The sovereign immunity doctrine is no longer a healthy manifestation of society. It is, in fact, an excrescence on the body of law. It encourages irresponsibility in the world order. It generates resentments and reprisals. Sovereign immunity is a stumbling block in the path of good neighborly relations between nations. It is a sour note in the symphony of international concord. It is a skeleton in the Parliament of Progress. It encourages government towards chicanery, deception, and dishonesty. Sovereign immunity is a colossal effrontery, a brazen repudiation of national moral principles. It is a shameless fraud." As we've heard today, I believe, given the King's Project, I believe it's, as I said, to the immunity of both UN and international organization themselves. Just one other point, one closing point is, I didn't really talk about the issue of immunity and non-UN, non-international organization humanitarian workers, because they generally don't enjoy immunity. One exception is the International Red Cross and Red Crescent Society in Geneva. They often do have immunity in some of the places they go into, but they're much more likely to lift the immunity than the UN or other international organizations. But as a practical matter, the civilian staff of NGOs in some of the fields of operation where the legal systems are either non-existent or terribly deficient, although they don't have formal immunity, in fact, they have practical immunity. And going back to what Parosha said about the need for extraterritorial application of laws for this accountability of this behavior, absolutely something that's necessary. I completely agree with her. And the some of the sex tourism actually get to that, actually can. But their application is quite limited this time. So much.
Thank you, Ed, for that very powerful account of the formidable challenges to achieving accountability that we are facing, and again, some positive concrete suggestions for progress. Have any questions currently that I can see? Do put some in if you would like to ask questions. I think probably, given we've got quite a large community online here, that attests to the authority and expertise of our speakers. I do have a number of questions, and I'm going to start perhaps with the trickiest, which is given the hurdles and the challenges that we've heard about, how do you think we can start to build political support, whether that's at community, country or UN level, for the approach that and the approaches that we've discussed today? Ed, I don't know if you'd like to start in there.
Sure. I think at least when I think forming the and making it accountable for the actions of its staff, whether it's the civilians. Again, the peacekeeper issue is a bit more difficult because they're not really staff members of the UN and they are subject to the status. But for the civilian staff of the UN, holding both the organization and perhaps the managers accountable might be a start. Which today, as a practical matter, because of the UN and IO immunity, every time there's an outcry or an example of sexual abuse at the hands of international or UN, the response seems to be, well, we'll have a new we're going to come up with a better policy, but in practice, nothing ever changes. And I think the only time it's ever you side is with a revision of the current that they there being any accountability either in the of the where the operation that raises other issues, or in the home countries of the humanitarians themselves or the organizations.
Would you like to come in there?
Thank you very much. So on how to garner political interest in this, I have some direct experience from the Commonwealth side, because I'm the senior legal advisor for the Commonwealth Parliamentary Association, UK's Modern Slavery Project. That's the Modern Slavery Project of the British Parliament, which was established in 2017 to support Commonwealth states in amending their laws. And what we found was that once it was known to parliamentarians across the Commonwealth that there was a project based in the UK that was willing to support them in their interest or desire to reform their laws, the CPA UK was being approached by parliamentarians. And so as a direct result of that, 3 significant parliamentarians from Uganda, cross-party, then sought the support of the CPA UK and through that myself to advise on new legislation to better combat modern slavery and human trafficking. And their anti-slavery bill 2020 was just read for the first time in their parliament in January of this year, where we do novel things such as criminalise the actions of recruitment companies who have been involved in deceptive practices for human trafficking. So I think what I'm trying to say then, using that as a parallel, is that I'm sure that parliamentarians in some of the countries where the abuses occur would be very keen to start conversations that could lead to the stemming of impunity for those who commit abuses. Well, to
Thank you. James, I don't know if you've... Yeah.
Well, I just want to say, I think we've lost Edward, but I'm in no position to talk about sort of garnering political will. But it does strike me that everything that we're discussing and doing today builds into this picture of public outrage, which is what is necessary, at least for the foundation. It's the vehicle upon which we're going to be using it. And we can have, there's the issue of media reports, yes. campaigns, yes. All of these things fit together. And I have no doubt that if and when these matters go to court, at least in the UK, these will be quite high profile cases upon which High Court Family Division judges are going to be lambasting the structures in place and calling for change. It's not the remit of a judge, of course, to bring about this change, but at least make observations, be it how these victims are handled during the court process, that's one thing, but two, how these people became victims in the first place.
Thank you. We've got a question in the chat. Value in non-legal approaches, for example, the misconduct disclosure scheme, an aid worker registration scheme to facilitate exchange of information about sexual misconduct between aid agencies. We lost Ed, so either Parosha or James could respond. Might be more difficult for both of you as lawyers there.
Possibly.
I certainly don't know about the misconduct disclosure scheme and the aid worker registration scheme, but certainly I always see that there's a value in non-legal approaches, but I would always say it's in conjunction with legal approaches. It's almost like a spectrum of responses that are needed to make sure it draws down at root level. And this seems very interesting, the facilitation of exchange of information about sexual misconduct. It's absolutely critical, I would have thought. So yes, thank you for that suggestion.
I'd say too as well that one dimension is punishing, but also it is helping the victims, and they're not always on the same platform, are they?
No, and we have another suggestion in the questions. Is it worth exploring HR treaty terms as an end route to immunity, and also building political will?
Yes, can I just say something about immunity? There's some very interesting case law at the moment going through the British courts on immunity for diplomats, because as a parallel to the UN immunity, certainly diplomatic immunity is something that's always been very, very tough to break through, and it's required the political will of the state of the diplomat to lift the immunity. But in human trafficking cases, there's been a lot of developments in the US courts, which have now been responded to by litigation being brought in the UK courts, whereby if a diplomat traffics a worker, such as for domestic servitude, the kind of cases that we often hear about in the embassies, who are kind of locked in and they're treated as slaves and not paid, but they've been brought from the country of origin. And so they're even more vulnerable to exploitation and abuse and with no voice. Then the Supreme Court, in a case called Al-Malki, in 2017, found that a former diplomat could be susceptible to proceedings, civil proceedings for damages, because they had left the protection of the diplomatic structure. But there's now a case that's going through the Supreme Court at the moment, looking at what about if somebody is still, in the employment of a embassy or consulate, and if they traffic somebody, are they open to being prosecuted or open to civil liability? And it's an interesting one, because what it boils down to is, was the trafficking of the person, quote unquote, in the course of commercial activity? Because that's the employment that the diplomat is being employed for. And I'm wondering, within the context of the aid workers, as an analogy, could it always be said that the sexual exploitation and abuse of a person was never within the contract terms and therefore should not be ever protected by immunity? Now, I don't know if that case has ever been run against the UN. I suspect it hasn't. I haven't found it myself. And so what would be a question for us to consider as lawyers, whether or not we should bring that kind of case and start chipping away at immunity anyway. But that type of immunity, let's not forget, doesn't exist in the civilian aid worker context. So, we've got two different spectrums of abuse. And my principal comments today have been on developing reforms for civilian aid worker abuse to protect that from happening, because it hasn't progressed in the same way as the UN has had some guidelines, etc. But then, of course, they won't let anyone sue them.
Thank you. I think we've got just about time for one more question, which is, are there any UK laws that you would recommend reforming or extending to support action to tackle exploitation in the aid industry?
Perspective. I think that it's a form of exploitation that should fall within the parameter of the Modern Slavery Act, but I think it would be difficult to interpret it at the moment as it stands. And so I think it would be a point worth considering as to whether or not we should look at the wording of the Modern Slavery Act to see if the wording itself would support this type of prosecution. And if it wouldn't, then what would the wording need to change? How would it need to change? But again, like our Modern Slavery Act is very weak in terms of compensation to victims. So, an extraterritorial jurisdiction is only for trafficking. It's not for holding someone in forced labor or slavery or servitude. So we've got quite a lot of weaknesses in our Modern Slavery Act. Anyway, another thing that's very important is a thing that was mentioned earlier by one of the colleagues, which is about donors giving donations. And they should actually have some quite robust inspections of what's going on. When I say inspections, I'm not saying in person, or that could be one of them, but to actually have an interest in whether abuse is taking place, and to require some reporting of that and some confessing of what's been going on before they give the donation in the first place. And that, I think, kind of links in with transparency and supply chains provisions in some ways. Because it's the services of the worker, the aid worker, that is actually exploitative. It's being used for the wrong. The position of power is being used for the wrong outcome, abuse. So yeah, just another thought. Thank you.
Thank you very much, all of you, for a really thought-provoking, interesting session, which I think we can learn a lot from as we move this project forward. And thank you to everybody who has attended and for your questions. The next session is going to be back on the page, and it will be a presentation by Professor Andrew MacLeod on the need for the creation of an international body to find victims and to perpetrators. So I hope to see you back on the main stage for that, and then we've got 2 final sessions after that on hurdles to scaling up and a final round table to discussion. So I hope you enjoy the rest of the conference, and we'll see you again in a couple of minutes. Thank you, everybody.
Thank you, everyone. Thanks.
Thank you.